Thank you for tuning in to the channel. Please like, share, and subscribe if you like the material. Jehovah's Witnesses are a big corporation, billion-dollar corporation that has no problem suing anyone that gets in their way. On top of having endless funds, they also have free volunteer attorneys. Have you ever hired an attorney? How much did it cost you? Maybe $3.50 an hour? Yeah, $350 an hour. Well, imagine Jehovah's Witnesses could put 10, 20, 30 attorneys on your head, and it wouldn't cost them a dime. Jehovah's Witnesses just lost a case where they spent years suing one little small channel on YouTube. And the word on the street was this, that individual was so afraid and did not have the financial backing, perhaps, I'm not sure, that he went and deleted a lot of his material to keep the big bully off his back, just in case things ended in Watchtower's favor. Recently, on my Patreon account, I posted a story about a friend of mine that invented the Young People Ask book, and how Jehovah's Witnesses headquarters allowed him to die, refusing to pay for a cancer removal surgery, because they said it was too expensive and dedicated funds. However, they have no problems spending money trying to shut down a small channel on YouTube. Whenever an individual uses the legal system to bully others, to intimidate them from expressing their words, their art, their feelings, you know something is wrong. And now we see the XJW community following in the footsteps of Jehovah's Witnesses. We see a lot of lawsuits from one channel to the next. What is going on? Many people enjoy watching the videos. However, they do not realize the big risk that's involved in trying to go up against a big billion-dollar corporation like Jehovah's Witnesses, better known as Watchtower. Even if a YouTube content creator was receiving a lot of donations and had a lot of Patreons, 500 to 1,000, it will still be hard to weather the storm against a lawsuit from Watchtower. I've often wondered why there were so many channels, great channels in the XJW community that tanked and the people never came back. Notice this article from yesterday, May 23rd, 2022. Jehovah's Witnesses run away from bogus copyright claims after judge realizes they're just trying to intimidate critics. Earlier this year, we wrote about how the Watchtower Bible and Tract Society, better known as Jehovah's Witnesses, despite a long history of litigating many important First Amendment cases, has thrown away its reputation as a staunch defender of free speech rights by massively abusing the DMCA subpoena process in an attempt to identify and intimidate critics of the religion. In the last few years, Watchtower has filed over 70 of these subpoenas, insisting that it needed to identify the alleged infringers in order to bring a copyright lawsuit. Of course, the real reason was almost certainly just to find out the names of the organization's critics. This belief is supposed by the fact that Watchtower basically never followed up with these subpoenas with the actual lawsuit it claimed it needed the information to bring. Indeed, the case that we're talking about here is the exception to the rule, and it appeared that Watchtower only sued because a court agreed to squash the subpoena. Public citizen litigation group's Paul Levy represented the target of the lawsuit using the pseudonym Kevin McFree, and the latest update is that the Jehovah's Witnesses have turned tail and run right out of court once they realized they were likely about to be in serious trouble for their abusive efforts to intimidate and silence a critic. The full story is really quite a read. This is only a part of it, but it should give you plenty of reasons to want to read the whole story. During the hearing, Watchtower's counsel made the outrageous statement that Watchtower's litigation strategies were confined by a lack of sufficient funds, and that its approach to the litigation was guided by significant economic motivations. Bottom of page 18 of the transcript. Because Watchtower's 99 OT forms are publicly available as required by law, it is a matter of public knowledge that Watchtower has more than $1 billion in assets.
Expediting the construction of new kingdom halls and remote translation offices. And we explained some of the financial challenges we were facing in being able to do so. We discerned that contributions immediately went up by more than 15% for the months of June and July.
Watchtower is fortunate that it never made this representation about limited resources in a signed document. At our suggestion, the court asked the parties to agree on a briefing schedule for the planned motion to squash, but that proved not to be possible because Watchtower made clear that it was going to try to pursue discovery having nothing to do with the copyright claims. Rather, Watchtower told us that it planned to use the infringement action to pursue the question of how McFree had obtained the previously unpublished videos. The Watchtower headquarters is a leaky sieve, and it wants to identify the leakers. Beyond that, there may have been a massive hack of Watchtower's computer system several years ago. Watchtower made clear that it was planning to seek discovery on those issues as part of its opposition to the planned motion to squash. It demanded a briefing schedule that would have allowed it to postpone explaining how it could obtain McFree's identifying information despite the res judicata defense until it had had the opportunity to pursue discovery. At the same time, it told us that it was willing to drop its lawsuit with prejudice so long as McFree was willing to agree that he would never use any of the Watchtower materials before Watchtower's own publication of those materials without Watchtower's consent. Of course, under the Supreme Court's decision in Bartnicki v. Vopper, McFree has every right to use leaked, unpublished materials, even if obtained from people violating the confidentiality contract, and even unpublished materials obtained by illegal hacking, so long as McFree had no involvement in the hacking. And although the possible hack of Watchtower's computer might well have been actionable under the Computer Fraud and Abuse Act, the statute of limitations on the cause of action expired years ago. So it became apparent that Watchtower was trying to leverage a bar copyright claim and that the threat of identifying McFree to obtain relief and or discovery on a different subject entirely, a possible abuse of process. McFree rejected this proposed settlement outright, and we warned Watchtower that if it persisted in the litigation, we might file a document blocking it from the voluntary dismissal without prejudice, thus locking into litigation that it was sure to lose. We urge it to drop the case immediately. And yet, interestingly, Watchtower was not pursuing identical copyright claims against another YouTube user, Lloyd Evans, blogging as John Cedars, who used the same unpublished videos that McFree had used and many more. Wait a minute. So Watchtower went after McFree, but did not go after Lloyd Evans? Watchtower did not go after Lloyd Evans because it knew that he was not going to take any guff. Wait a minute. You mean Watchtower thinks Lloyd Evans is a superhero? Watchtower represented that the reason it had pursued the anonymous Kevin McFree for his use of the unpublished 2018 video instead of filing an infringement action against Lloyd Evans was that it had not known of his use of such unpublished videos. Wait a minute. We have to ask, why is Watchtower giving Lloyd Evans a pass? In fact, Watchtower's in-house counsel submitted an affidavit averring the Watchtower did not learn about a particular Cedars video until September 2020, when McFree mentioned the video in his papers. But we learned, in the course of investigating the case, the Watchtower sent Evans a demand letter in 2018 pertaining to his use of the leaked and unpublished convention videos from that year. That letter cited the URL for Evans' YouTube channel and made clear the Watchtower was monitoring its content. It is hard to believe the Watchtower's assertion that it did not know until 2020 about Evans' use of the same material on which it's pursuing McFree. And finally, in the course of investigating the case to prepare for briefing, we obtained useful information to address Watchtower's false assertion that it wanted to identify alleged infringers only for the purpose of pursuing copyright claims against them. Watchtower succeeded in using a DMCLA subpoena, obtaining the identity of a previously identified blogger who specialized in attacking child abuse within the group, and Watchtower refusal to report abuse to local authorities. Shortly thereafter, it initiated disfellowship proceedings against him. It is quite possible that Watchtower did not need the information it obtained under the DMCA because the blogger's identifying information had become available elsewhere. But even so, it never sued him for copyright infringement, and it never otherwise used his identity to enforce its copyright. Watchtower had got what it wanted: revenge. The end result of all of this, however, is that Watchtower agreed to dismiss the lawsuit with prejudice, which also allows it to avoid claims to recover attorney fees, and there was a very real risk of having to pay up, as copyright is one realm in which the Supreme Court has been open to making frivolous lawsuit filers have to pay up. While it may be disappointing that this case didn't lead to the final ruling from a judge, hopefully by admonishing the Jehovah's Witnesses for their long-standing abuse of the DMCA subpoena process, one hopes that how this case played out has been something of a warning to the group not to continue abusing copyright law to attack and silence critics. I assume, at least, that Paul Levy will continue watching.